Thank you.
Mhm.
So this is the call to order for the legislative and policy meeting on October 12th, or I'm sorry, that was the meeting minutes from last time. We're on January the 25th today. And since we've changed over, this is Jennifer Munson. I am now the chairperson. We have John Melnichik as our vice chair, Clifford DeFore and Kathy DiMarino on the committee. With the folks, all right, everybody adjust your camera if you needed to. I think we're good. All right, first item on the agenda is to approve the meeting minutes from October 12th, 2020. Did anybody have, or I'm sorry, may I have a motion to approve?
So moved.
And any comments on them? Nope. Okay, then all in favor?
Aye.
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 All right, moving on to the PSBA policy changes. So these are recommendations coming from the Pennsylvania Board Association. The first one is policy 103, approval to move policy 103, discrimination, Title IX, sexual harassment affecting students to full school board for first reading. May I have a motion?
So moved.
All right, thank you, Clifford. And looking at this, the main changes were, I think, just some wording around students convicted or adjudicated of sexual assault. And Dr. Marchini, anything else we should be paying attention to in this draft?
Yeah, this policy 103 and a lot of the others that are here for PSBA are related to the Act 110 that was put into law in November 2020, related to the phrase you just said, that adjudicated students would have to be removed away from the victim of any kind of sexual assault or sexual crime.
Okay. So committee members, is there anything that you want to discuss on this particular one?
I'm just curious, is this then a brand new policy or there's just changes? Sorry, I'm kind of new to this party.
Yeah, okay, no problem. So when you're looking at the executive view, you'll see two versions. One is a draft and the other is a final. If you open up the draft one, the changes will appear in a different color. So this is an existing.
Oh, the green,
policy.
okay.
Yep, exactly. When you get to the green section, that's the section that is changing. In this case, it looks like it's being added, and I'm not seeing much that's being taken away except like making the D in district capital in some cases.
Okay.
All right, any other comments before we move this one along? All right, all in favor?
Aye.
Okay. Next is section 3.02, policy 113.1, discipline of students with disabilities to full school. Yeah, the motion will be to move that to full school board for first reading. May I have a motion?
So moved.
All right, and in this one, it looks like positive behavior support plans. In every case where it previously said behavior support plan, it now has the word positive included. They're trying to take out gendered language like his, hers to say the student instead. There's a section at the bottom of page 3. Shall ensure compliance with the Family Educational Rights and Privacy Act. Actually, they're just rearranging that sentence. The district shall ensure compliance. when transmitting copies of the student's special education and disciplinary records.
So on,
Yeah. Go ahead, Clifford.
no, I'm sorry, I got lost where you were. I got,
Yeah, I'm just trying to scroll through and look at anything that's green, and I'm not seeing major changes.
yeah,
This is a
most
point of-
is terminology changes.
Yeah,
Right.
Yeah, terminology changes. I just ran into a page on 3.4, where it talks about a weapon. And it's kind of odd because it's trying to define the weapon, but anything can be used as a weapon. So I know it's a wordplay, but if someone picked up a brick and hit somebody with it, it's a weapon, but in here it's not defined as a weapon.
yeah, the reason this is on the agenda was because it's related to 103's changes with Act 110. So basically, if a special education student or a student with a disability, including a 504, was to be expelled from the school for an adjudicated sexual offense, there would have to be certain certain procedures by law to go through. So that's why the PSBA decided to add this on here.
Right. So
So you're reading, I believe you are correct, Clifford, in that if a student brings a brick to school, that brick is not defined as a weapon.
or picks up a brick. Right.
Well, it specifically carries a weapon
A weapon.
to or possesses a weapon at school, on school property, or at school functions. So we can't expel them because they brought a brick.
Or picked up a brick that was just laying on the ground and used it as a
Right,
weapon.
so, well, they could be expelled for the act of injuring somebody, but they can't be expelled just for bringing it.
Just for brick, or just, or right.
That's
or,
my reading, but
Yeah.
see if you can.
Well, it does say it does say is readily capable of. So that makes it kind of vague in that any object that could be used as a weapon is not.
No, yeah, you're right. I was just hung up on the first part. It says possesses a weapon at school property, right? So if they pick up a brick that's already on school property and use it as a weapon, it's technically not according to this. Not a
But
weapon.
then number 3 would kick in, not number 1.
Yeah, number 3 should, yeah. It's just that it wouldn't be construed as a weapon, even though it's.
Yeah, I understand what you're saying.
Yeah.
That's true. But that point 1 does say that if you brought a brick to school.
Well, no, yeah. So the scenario is a person gets mad at another person. They're outside. There's a brick laying on the ground, and they pick it up and they smack them in the head. Number 3 would apply, but not number 1, even though the brick was used as a weapon.
Right, but if they brought a brick to school, number 1 could apply because it's
It
readily
would
capable.
apply, but if they, like in this scenario, the brick is just laying on the ground, so they picked it up
Yeah.
and hit them,
Right.
So
But it says possesses a weapon, so even if it was already on school grounds, if they pick it up and make it into a weapon, then it would kick in.
Right, but I don't think we should be expelling kids for bringing things that are not necessarily weapons. So,
But that could be.
well, so if somebody brings a brick to school and they don't use it as a weapon, should we be expelling them?
I
No.
don't think so, but I think that is readily capable of clause makes that a possibility.
Mhm.
So that's why I think that maybe that needs to be taken out or changed so that any object that could kill someone doesn't become illegal to just bring to school, even if there was no intent to do something with it.
So how would we change that? Just remove or is readily capable of?
With intent to harm.
Oh yeah, so a lot of law is around what's called mens rea, which is intent.
Mhm, right.
So if they intend to harm someone by picking up an object, any object, could be a brick, could be a rock, and use it, we should consider that as a weapon. And I'm trying to make sure that that's covered here, right?
Yeah,
It not only has bodily harm, but it also is a weapon, right? There was a court case where a guy threw his cell phone at another person, hit him in the heart, killed him. That cell phone became a weapon, even though,
Right.
you know, they had it in their possession. They, you know, it wasn't intended to be. Cell phones are not intended to be weapons, but it was used as a weapon. So I'm just trying to make sure that that law covers that type of scenario. And that's where I got held up on, is the weapon or possesses a weapon at school part or on school property, right? A cell phone or a brick is not necessarily considered as a weapon, but it can be used as a weapon. So maybe I'll get more thought behind this and make a suggestion to change that to cover those scenarios. The bodily harm is obviously a factor in number 3, but we want to make sure that people who are using inanimate objects as a weapon, that it's covered under a weapon. You could pick up a rock and
Covered or not covered?
What's that?
Right, just getting caught up in the, you know, that we want to make sure that it's covered or not covered, because this is the definition of a weapon. So we want to make sure that we do define weapons in here, but it should only be the set of weapons that are serious enough that bringing them to school should be a big alarm trigger for everybody. So
Yeah, as well.
you
Yeah.
can't go expelling students who bring cell phones.
Right. No,
We
you're
have no
right.
students in the high school.
Right. So, yeah, right. So it would, what it would be, and that's, I think
Yeah.
that's what I'm held up on, is like a weapon can be anything, right? That
Yep.
kid with their laptop and hit another kid in the head. It's not a weapon, but he used it as a weapon. So I want to make sure that that's covered here somehow.
Would, and I know, I'm sorry, I'm not on the committee and I don't usually get involved, but before they come for final vote, I feel I need to at least check.
Going great.
Is some way to verbalize that when the student acts with intent, it is differentiated from bringing a weapon of intent. I don't know how you do that, but I think we do need to clarify that somehow. So Dr. Marquiti, can you help us?
Yeah, could admin give us a help?
Yeah.
If you see at the end of that paragraph, number 1,
Okay,
it has a little bracket, 29 is a hyperlink. That definition of a weapon is by the state law in schools. So I'd be hesitant to make any have us make any specific changes to that definition, because if we make a change, it could be not within the Pennsylvania state law on weapons in schools.
But I don't think we can supersede the Pennsylvania state law.
Correct.
Certainly add on.
I see.
In,
Right. There's a difference between superseding a law and adding on to it.
yeah,
So this would be in addition to that law. We're not superseding it.
The
right.
exact same words.
yes. If you go on that link, it's the exact same words. In practice, just to answer your question, a student would not be expelled for bringing a brick to school. However, if they threatened to hurt someone with a brick and had one in their pocket, it could cause them a problem.
Okay.
You know, a student might not be in trouble for having a box cutter with them. You know, we're in their car, they're on the way to work and they work at a FedEx, UPS depot, and they open boxes all day and they happen to have it with them. If you go to the technical school, a chef student, you know, a culinary arts student has a knife, that would be a tool, etc. So, you know, in some cases there are extenuating circumstances, and that's taken consideration in practice based on this law.
Yeah.
If you'd
So, right.
If
So
you
my,
add something you can.
yeah. So my, I guess my contention here is if a student takes their laptop and hits another kid in the head,
That's bad.
which we all agree is bad, is that laptop considered as a weapon?
But then they're not in trouble for bringing the laptop, they're in trouble for hurting the other student.
Yeah, that
Right.
Right.
Yeah.
According
That-
to this, and that's why I was kind of questioning the definition of a weapon. That it's not, we're trying to define a weapon, and I understand we're trying to define, you know, what a weapon is, but some cases you can't define exactly what a weapon is, but it comes back to mens rea, which means that their intent to use an object as a weapon.
correct.
Right. Intent to use.
Yeah, intent to use an object as a weapon is a,
Mhm.
Is there a
Right.
recommendation from the committee to add any language onto any of these 3?
Well, I
Well-
would say that the language I would consider adding would be that any object used with the intent of any object in possession used with the intent to cause bodily harm, right? So that would be, I picked up a laptop, I picked up a chair, I picked up something, I'm using it to inflict damage to another human being.
So we
And
would make that change to the first sentence, not the second one? To add
would-
the intent?
would be right. The first sentence, because the first sentence, the spirit of that first sentence is carries a weapon or possesses a weapon at school, right? And so that they don't necessarily have to carry it or possess it at school. They are in possession of an object that they use to cause bodily harm, which is a little bit different than having a weapon. But Dr. Martini, you can.
I know I'm not on the committee, but can I just interject for a moment and say that I think your intention, Cliff, is spot on, but I think it's covered because number one is if I pick up anything and hurt somebody, I pick up the brick, I pick up the laptop, I pick up the cell phone, and I hurt somebody, then that's covered in, I'm sorry, number three. Number one is saying for what is defined by the PA as a weapon and I have it on my possession, I can also be expelled. So I can be expelled for three different things. I'm carrying a weapon as defined by Pennsylvania. I'm knowingly possessing illegal drugs, or I'm hurting somebody, however that happens, whether I pick up a brick, a cell phone, or I have the knife, in which case I get both 1 and 3 against me, not just 3. So I do think they're all covered.
Right, and my concern about modifying the first sentence of number 1, the way that you just suggested, Cliff, would be if somebody brings a firearm with bullets to school and we
Well, this would
can't
be
expel them
yeah.
unless we can prove intent.
Yeah, it would be in addition to, it wouldn't be to remove it. I think that should be
This-
there too, because
Right.
I think where I struggled at, and we can move on from there and just table it, is that I want to make sure if someone gets angry, picks up their laptop and hits them with it.
So you'd be adding the intent to number 3.
Well, the intent is the bodily injury. So if I bring a weapon to school and let's say I try to use it, but I don't, and I miss the person, right?
You
I think
still can't, you're still in trouble if you bring a
You're
weapon.
still in trouble,
Right.
right? So that's why that needs to be there. And number one, where they carry a weapon to school with the intent of causing bodily injury.
No, carrying a weapon, you can carry a weapon without intent, but you're not allowed to carry a weapon whether you have intentions to use it or not. So that's covered under number 1.
Yeah.
Number
that's
3
what I'm
is
saying,
I
it's covered under
inflict
number
bodily
one.
injury. Let me finish. Number 3 is I inflict bodily injury, but you're saying, okay, great. You try to inflict that bodily injury, but you don't. You still intended to. So Jennifer, I think what the suggestion is in number 3, we have to add in language that would not only have the actual infliction of bodily injury, but the attempt to inflict bodily
Intended.
injury. And then I
Yeah.
think covered.
So
So
let me
has
just,
inflicted or intended to inflict?
if I could just interject one clarification, this policy is very specific to these 3 things aren't our total, they're not our discipline code. It's if you're going to be removed on a unilateral 45-day alternative ed setting. And it's specifically for special ed students. And so according to the law, only these 3 things very specifically could cause a student, regardless of their disability, to be removed from the school. If it's not in here, they can't be removed from the school by law. So,
Okay.
you know, if, as you read it, it's very difficult to change it because you'd be changing a special ed law of how to remove a student for 45 days without even considering his disability. And that
Yeah,
would be,
and I'm not asking to change it. I'm asking to
Yeah.
add on to it.
okay. I just want to make sure you're,
Yeah, I'm not
Yeah.
asking.
Well, it is a change because you're suggesting additional scenarios in which the student could be removed.
Right. So if we're comfortable with if someone picks up a laptop and hits someone in the back of the head, it's covered under here, then we can just move on, right?
yes.
Yeah.
I feel like it is.
And comfortable with this policy as is?
I think it's fine.
Yeah.
Okay. So,
Yes, this policy has served us well.
so this wording is unchanged from what the the school has been operating under.
Yes, absolutely.
So committee, are we okay to move this on to the full board?
Yes.
All in favor?
Aye.
Aye.
Okay,
Mrs. Munson, just as a
Yeah.
point of, you just need a motion to move it forward, not a vote.
Yeah.
So just
oh,
a,
okay, so I'm doing it the other way around, so I should be having the discussion first and then the motion?
yes.
Yeah.
Thank
They have
you.
discussion. No, that's okay. Discussion, and then you just ask for a motion to move it forward without a vote.
Got it,
Okay.
okay. Thank you.
Jennifer, this is the most difficult chairmanship of our committees, let me tell you.
I think I'll have it down, right?
It's so exciting and
All
Right.
right. We are on 3.03, policy 113.2. This one, it would be a recommendation to approve 113.2 behavior support to the full school board for the first reading. And in this one, it looks like there's additional wording around LRE as the abbreviation for least restrictive environment, and IEP for individualized education program. There's also an additional, so in the very first paragraph, it looks like an additional and cannot meet the needs of the student. Looks like adding the word behavioral to functional assessment. Oh, changing it around from functional assessment of behavior to functional behavioral assessment.
so again, it's just minor terminology
Lots of, yeah, terminology.
and it's been okayed by PSBA, right?
Yes. Yeah, that's the recommendations from PSBA.
I like it.
De-escalation techniques. Yeah, does anybody have any of these changes that they would like to call out for discussion? Okay, if not, may I have a motion to move it on?
So moved.
And a second,
Okay,
and a second.
and a second? Kathy, thank you.
Nice.
All right, moving on to 3.04, policy 113.4, confidentiality of special education student information to the full school board for first reading. And I see very minor changes in this one. Oh, until I get to page 5, there's a new paragraph, disclosure to law enforcement. Specifically saying district shall provide information, ensure that copies of the special education and disciplinary records are transmitted for consideration.
So I have a really, you're gonna hate me on this committee.
I'm gonna love you on this committee. You're bringing up good points. It's fine.
So on 4.6, where it says the district may maintain a permanent record, is district, when it specifically says the district, should that be capitalized?
Um,
On 4.6, like halfway down the page.
Yes. It
Oh my
actually is
God, right.
capitalized. in the so
Yeah, I got one
yes.
right. That should be capitalized, right?
Yes.
It's consistent, okay.
Yep, let's add that, because that looks like PSBA missed it and you've caught it.
Yep.
Good job.
We'll make that change.
Thank you.
Did you spot anything else? Okay, motion to move it on with that one change. We can do that, right, for a minor change?
Yeah.
With that change, yes, you can make a motion to move that on.
Okay,
So moved.
Good.
Right.
In a second.
all right, so I think I got Dr. Melanchak.
Second.
Okay, I think Clifford also said.
Oh, on, I'm sorry. Can we just do a search for the word district? Because I found another one
Mhm.
on 5.6, the first sentence.
Yes, we'll make a note to
Do a word search.
Yeah, we can
Mhm.
double check those.
have Mrs. Drumheller do a search on the word.
Thank you.
All right. Moving on to item 3.05, which is the approval to move policy 122, extracurricular activities, to the school board, full school board for first reading. And this one, there were some additions in the off-campus activities section that I think our school welcomes because it adds some clarity that we were lacking before. Did any of you have items you wanted to discuss on this one?
So the spirit of these changes looks like it is to extend it beyond off-campus conduct, right? Beyond school grounds. And that is only when school is in session and there is a club associated with the school. Am I getting this right? I'm getting that
That was
right?
the previous wording.
That was the previous wording.
Now the expanded wording includes 3, 4, 5, and 6 on
Okay,
page.
so Dr. Marchini, can you just real quick, when it says activities, can you give me examples of activities?
Yeah, so for these, it would be that a student is a member of the extracurricular activity and they've been notified. So let's say, for example, they go to a fundraiser, they're out together as a team, and they've been told by the coach what the code of conduct is based on, the school's code of conduct, and they would violate that, which means they'd be off campus. However, they're still part of their extracurricular activity at the time.
Does that also include field trips, I assume?
Sure, absolutely. Yeah, as a group, yeah. And, that would be a school-related activity as well.
What about, right, and what about club sports that are not, our students attend, but and they use the Owen J. Roberts name, like rowing, for instance, right? Would it be extended, would that be considered as an activity?
It would depend.
Right.
Yeah, it depends. We do have activities that are under an umbrella of our school activities, and there is a specific code of conduct, but the students also have to be notified of the code of conduct.
Right, so it has to be supported and approved by the board. So I'm reading the definitions, I'm sorry. Reading the definitions says supported and approved by the board. But there are some activities, I believe, that are not approved by the board. And this is under definitions. You can correct me if I'm not reading that correctly.
Yes, it's on the off-campus activities.
Right, so where it says the purpose of this policy, extracurricular activities shall be those programs that are sponsored or approved by the board. So the word sponsored means that we would have to, Owen J. Roberts, the school district, would sponsor those activities. So in the case of rowing, that we don't sponsor or approve by board would fall under activities.
That's a difficult question because rowing has been at some time sponsored and it has not been at some time sponsored.
Okay.
If you picked a different activity, I might be able to answer it. Sorry.
No, that's okay. I get real.
So yeah, I guess
coming out. It's very binary.
my understanding is that anything that we vote on as a club or activity, because clubs arrive on our regular agendas, or the other thing that arrives on our agendas would be special field trips, like students attending a conference together. So those would be specifically included. Do you have a question of what would be? Yeah, so I guess your question was around like community sports where.
Well, yeah, there are some sports that are not really school sponsored, but our students attend. So let's say that one student causes harm to another student while at one of these sporting events or whatever. Is that covered under this policy? Because I was just reading the definition, and Dr. McKinney is actually absolutely right. Sometimes it's sponsored by O&J, and sometimes it is not. So I wanted to understand what the extracurricular activities, what the definition of that is,
Yeah, it would have to be approved by the school board as an extracurricular activity.
Correct. Yes,
Right.
we do get into legal issues when we try to control students' lives outside of the school district. And we have to be wary of that, very wary of that.
But this
Are there-
number 3, Ms. Booth, are you able to see the number 3 changes? A member of an extracurricular activity and has been notified that a particular off-campus conduct could result in exclusion from such activities.
I can't see that right now. I was trying to pull it up on
Yeah,
my other page here, and I didn't pull it up. I just want to make
Dr.
sure that we are very careful about intruding where we're not legally allowed to intrude, but we still need to be attending to those that we do have some impact on and some control over. I know it's a legal issue and it has come up in the past, and it can cause us harm in
Mhm.
that, in legal issues, but we also want to protect our students as best we can and when we can. I'm just bringing it up. We don't want to intrude too much, but we do want to have some form of access to let children know how they had to interact with other students.
Right, so our bottom line is to protect the student.
Right.
And,
If-
and
If
that,
we though are
practice.
sponsoring that, if we are sponsoring, so
Oh,
one of the teams,
Absolutely. If we
like
sponsor,
the mountain bike team, we let them use our name. And I know they follow all these policies and notify the kids every year that they're expected to live up to these policies as well as academic policies. But if they didn't, let's say they didn't, we still as a school are allowing them to use our name and represent us out in the community. And in that case, I would think that we would have every right to be able to hold them to these things. Is that correct? Now, if we're not sponsoring them and we're not giving them our name, then that's another story. And that's where we land into,
well, I
into
don't think,
legal issues.
yeah, O&J Roberts is a person's name, and I don't think we branded it or own it.
no, you can't brand it or own it.
Allow someone to,
No,
Okay.
affiliation. Let me say that the right way. Affiliation with the school. So
it's affiliate, right, it's affiliated, but we don't allow people to use our name.
no, but if we have an approved extracurricular team, club team, like the rowing team, and we're saying, yes, they are approved, they're in our yearbook, they're part of the O&J Roberts community as we've allowed it to be. Same with the mountain bike team. Same with I think the hockey team. There are a couple teams that are club teams, in which case, if we are bringing them into our fold and saying they are quote unquote sponsored by us and we are affiliated with them, therefore, I think we should hold them to these same, that's what we're saying in this policy, correct? Is that they are held to these,
Yeah. so-
right? Dr. Lloyd, Dr. Markini?
Yes, I think.
Yes, that, and so, Dr. Markini, it applies to 3 of those groups, right? The mountain biking,
Yes,
the rowing, and the ice hockey. Because they're parent sponsored but approved by the district.
Right.
the one
there-
thing
there's-
to be careful about with number 3 is I think this is talking about when students are part of their extracurricular activity off campus. The only thing I think is you have to be careful, and I guess that's the wording that you should discuss in number 3, is if a student is a member of the football team or basketball team, hockey, whatever,
That's a whole different
and they're
thing.
not with their team, and they're, they get arrested or cause a problem or get cited or out drinking, whatever they might be doing. I don't think that this is what this is talking about. This is when they're off campus as a member of their extracurricular activity, and they've been notified as a group of the certain code of conduct that they must uphold. And so while they're off campus and they have to uphold their code of conduct, and they don't, they could be excluded from those activities.
right. And I specifically wanted to discuss on number 3 that there would need to be, I think, some internal discussion within the school district of what can reasonably be notified as that an off-campus conduct could result in exclusion. Because yeah, getting arrested, I think we can all agree if you get arrested, like if you were told you'll be excluded from this activity if you get arrested, that would be reasonable. But if you say, like, I don't want any students who chew bubble gum, something completely inconsequential, we would not want any communication to students that they would be excluded from activities for inconsequential things.
My recommendation is that you, for the purpose of this policy, strike number 3 and move it forward. And I can check with our solicitor and then bring it back up for any other changes. It's just too open to interpretation.
It is.
There's some gray areas here, right?
Right.
Yeah.
That I was trying to point out, especially where it says shall be those programs that are sponsored or approved. And I'm not sure if it should be sponsored and or approved, but I guess the word sponsored is, I think Lydia was saying that means even affiliated or associated with the school, but not necessarily sponsored. You guys can correct me if I'm wrong, but that's food for thought, right? So that sponsored is, you know, we organize it, we maybe or maybe not fund it, but it's organized within the school, and the school is aware of it. We are certainly aware of the activities that go on that are like the mountain biking club, but I'm not quite sure if we are considered as sponsoring it.
And
Right.
I'm not sure how you would word that to include them other than the wording that's already here. So I think I would rather go with Dr. Marchini's suggestion of let's just strike number 3 if we're really not comfortable with that, and not get into the school sponsored versus school
Mhm.
Affiliated.
Affiliated.
affiliate, right? Yeah, because these are essentially things that have already been through a bunch of lawyers and compared to Pennsylvania law. So the ones that appear in the PBSA section, if we change them, it's best to consult with lawyers. And so I think we would want to do that if we're,
Yeah,
you know,
I
even
agree
for
with
this specific situation. I think it's a good idea to pass it along without number 3 and get advice on including number 3 at a later date. So can I have a motion to move this without number 3 on page 2 to the full school board?
So moved.
Second.
And second? All right, thank you. All right, next one is 3.06, which is the approval to move policy 123, interscholastic athletics, to school for full board for first reading. I'm seeing minor changes here. The biggest change is a change in a link. Any discussion? Motion to move to the full board.
So moved.
Second.
Second.
All right, thank you. All right, policy, I'm sorry, number 3.07, which is the approval to move policy 123.2, sudden cardiac arrest, to full school board for first reading. I think this has been updated for wording around electrocardiogram testing. Any questions or comments on that one?
No.
And motion to move it to the full board?
Move.
Second.
Yeah.
All right, thank you. Item number 3.08 is the approval to move policy 2.18.3, discipline of student convicted adjudicated of sexual assault, to the full school board for first reading. Now, this one is a new policy, so you'll notice that the description on the file says new policy. So this is something we don't currently have.
That's correct. This is based again on the Act 110 law that was just put into place. So there's a recommendation to have a policy specifically on that law.
And then we'll switch for the word district on here as well and capitalize where necessary. I see a few places.
Yeah, I just looked ahead at that. I think we got most of them. Double check.
A lot of Ds.
Yeah.
Yeah, I see it.
Right. Oh, and this one was the one where I really liked the additional clarification. I think it will be very helpful for us to apply in future situations.
I just, I know I'm not on the committee, but I just do have a quick question with things that do occur. And the school district, I mean, I think it's a really good addition. I just want to clarify with Dr. Marchini that if a judge comes down with, even though the child is adjudicated, if the judge comes down with a different recommendation going forward, and because of this new policy, which I like, I'm not saying I don't like it, but does that put us in legal jeopardy going forward? If this student's parent would come back and say, you have breached the advice of the legal authority over this instance. I'm just asking, I like the policy and I like the clarification, but I'm looking for Dr. Marchini to say this has been considered.
Yeah, I think there's going to be, when this is initially tested, there's going to be probably some different authorities ruling differently on this. All we have is the law that says if they're adjudicated or convicted. There's nothing
Okay.
in the language that says we have to go by the court order or anything like that. So we would move based on the law
Okay.
to follow this policy.
Okay. I just wanted that clarification because I can foresee issues with that. I do like the clarification. I think we definitely need it in there, but I just like to cross those T's when we can to know that we've at least looked at that, and whatever happens in the future will be, I'm sure, notified if PSBA and law does slightly alter what they have laid down here. Thank you. Sorry, I'll get out of it.
No, this is definitely worth examining carefully. But I think we should pass it on with the existing wording. May I have a motion?
So moved.
Second.
All right, thank you. Then the last one in section 3 is 3.09. This is the approval to move policy 252 dating violence to full school board for first reading. So this one wasn't existing, but it has some additional wording being added on bottom of page 1, top of page 2. That looks like the biggest changes.
Yeah, I have a couple questions about this. I was not familiar with this policy, and I didn't know if any of this policy had been altered due to the new Title IX laws or not. But I guess my question would not fall be under that, I guess. But I'm looking at the definitions of dating violence, and I don't see anything in this policy, and please forgive me if I have this wrong, because I'm just trying to, understand this quickly. But this idea that dating violence could be, using emotional abuse to control a person's dating partner. I would assume that that type of behavior would not be happening in school, on the school grounds, or, on school property, or during a school activity or anything like that. And so I just don't understand how we would go about trying to control or, kids' behavior in their dating relationship. I don't know. It just seems like a very strange place for the school district to be interjected into teenagers' lives. Now, obviously, sexual and physical abuse is a completely different story, but say verbal abuse or whatever, if it's not happening during school hours or during a school activity or on school property, do we really have jurisdiction over that?
But I would say that for me, the intent is of two students have a conflict outside of school grounds. When they are on school grounds, right? If they're in the same classroom, or if they're with each other in the hall, that the one student education may be inhibited by the fact that there was an assault that occurred on a date outside of school. So would this apply when something like that happens outside of school grounds? Like to your point, Kathy, I don't know if we're trying to control what happens outside of school grounds, but when they are back at school grounds, I think this is where this policy comes into play, because there's always this these types of things are always hard when you have someone who was accused, but not the process of going through to prove the facts in the case are still happening, but the students are still in school together. That's always like it's a difficult place with Dr. Marchini. You can let me know if I got that right. It's when something occurs outside of school, but the students now are back in school, right? And it's to protect the victim and the accused, right? In some cases.
Yeah, there's two things. The Title IX, Kathy, you're right. This is part of the Title IX, in which dating violence is part of Title IX. And if a victim, files a Title IX complaint or complains to administrator, then we would follow the Title IX procedures in that case. So I think they added, or they certainly not added, but they included dating violence because, as Mr. DeFore said, most of the things that happen outside of school occur inside school too, and often the victim is uncomfortable around the person they're accusing. Secondly, the actual language that was added to this is if a student is convicted or adjudicated of sexual assault, which can be included in dating violence. So, dating violence could end up where the police are called outside of school. A student is adjudicated for sexual assault and/or any kind of adjudicated sexual related crimes. And that way they would then we'd go back into disciplinary requirements of removing them from the school. So I hope that answers both questions about Title IX and.
I mean, that makes perfect sense to me, that part of it. But I guess where my question is, or where I just really am wondering about the vagary of this wording, is the whole idea of verbal or emotional abuse, which is a very complex scenario, and not to minimize it at all as an issue in life. I know, of people that have been under this, but it seems to me that that's very vague of a term. And so to try to, you can be being verbally abused and with no crime committed. So I just am wary of that, using that very gray area and very vague term to be something that the school district would be having their hand in. Now, I guess if Title IX has specific guidelines on what constitutes verbal or emotional abuse and can actually, I don't know whether they have some sort of way to dictate that, but I don't know, it just seems like a very vague term to use especially with teenagers or kids.
It's also very individualized based on the situation, and that's why the Title IX process is put into place with multiple people being involved, so that there can be an investigator or a person deciding based on the information given from all the students involved. So it would be very specific to the investigation of the Title IX process.
And this is another case where if you follow the link after the words, those exact words are in the 1949 Act 14 definition of dating violence.
Yes.
So there must be
Yeah.
some legal precedence for using that vague terminology.
Yeah, okay. I know, I admit I haven't read the whole Title IX, all their policies and everything, so I'm not super well versed in it, but, okay. All right. I don't know, getting involved in dating situations when we're not talking about actual like physical or sexual abuse seems to be a bit strange for a school district, but if Title IX requires it, then I guess we don't have an option.
So do I have a motion to move this one to the full board for first reading?
So moved.
Thank you. Second.
Second.
All right, thanks. Okay, on to our discussions. First one is policy 005, organization. So we have the unmodified wording here of 005. And we had wanted to look at the definitions of our committees in here. Let's see. So if we're looking at officers, this was another thing that I thought would be interesting. I don't want to spend too much time on it, but there's on the bottom of page 1, there is the school director shall annually during the month of May elect a treasurer who shall serve for 1 year beginning the first day of July after such an election. The treasurer may be a corporation duly qualified and legally authorized to transact a fiduciary business in the Commonwealth and may be a member of the board. So I believe currently we have a treasurer as a corporation. Is that correct? Do we count?
I don't know.
Dr. Lloyd's on
Mrs.
mute.
Carmine, would you jump in here, please?
Yeah, we need Ms. Cumrine. I think you're right.
Yes, yes, she is the treasurer.
Okay,
She's
but I
the
believe she's also
secretary and
secretary.
Beth is the treasurer.
Right.
Yes.
We do. Yeah.
So
we
Jackie,
do
would you add your commentary here, please?
Yes, I just need to get caught up exactly where you are.
Yeah, so we're on policy 005,
Mhm.
looking at after the organization meeting and order, there's an officers section at the bottom of page 1 that refers to the treasurer, and then at the top of page 2 that refers to the secretary. And in both cases, it says, and may be a member of the board. And in this case of treasurer says, may be a corporation duly qualified and legally authorized to transact a fiduciary business.
I think these are all tied to the school code, but in the O&J Roberts School District, the board approves the board secretary and the board treasurer as non-voting members of the board. So I'm the board secretary and our director of finance, Beth Polinsky, is the treasurer.
Oh, so the maybe a member of the board essentially allows for that non-voting board member position?
Maybe a member of the board. Right.
I wasn't sure the intent behind that phrase.
Right.
Just an option that you have, Jennifer, that you could have a
Right.
board member do these roles, but we don't do it that way. So
Yeah.
Right.
Yes.
it's something I don't think you need to modify here.
The only
Right.
thing is we never really elect the treasurer. Like, should we be doing that in our organizational meeting? Should we be re-electing Jackie or, you know what I mean?
You do approve the appointment
do.
of the treasurer.
Mhm.
In the school code, it's every so many years you approve the appointment of the secretary and the treasurer. So like
Oh.
one rotates on a 2-year basis and one rotates on a 4-year basis. And I
Right.
can send you that information in board line so that you can see how it rotates.
Yes.
I'm happy to.
Yeah.
do that.
Yeah,
So
Jackie's
it
right.
says treasurer every May and secretary every 4 years in May.
Okay, I didn't realize that we had done that in May, but I guess we did.
Yeah,
Yeah.
we're learning.
Yeah, we do that because you're also approving the bank accounts and the treasurer's signatures actually on the checks.
Mhm.
So it's
Okay, well, okay.
for the
That's
treasurer.
fine.
In essence, we would have the ability as a board, if we wished, to appoint board members in those positions. But in the past, we have found it a much cleaner transition to go forward as we have in the past. That could always be changed, but we do have the option to change that and elect board members to do so. It just has worked much better with the situation as it is.
And then what we do is we have board oversight in having a finance committee, just so that
Right.
everyone's clear on that. Sorry, I'm not even looking at the right screen there. We have board oversight with the finance committee, and then the finance chair signs off on checks and the disbursements.
Okay, thank you very much for that explanation. I think that, does everybody else agree with me? We can just leave the wording as is?
That's
Yeah.
fine.
Yeah, okay.
This
So
is
then
one-
the part that I know we really wanted to get to
Yeah.
was page 3, right?
Yeah, I had a recommendation about that. You guys were looking at, the board was looking at the committees and the list of committees.
Mhm.
I had a recommendation because it seemed like change the committees based on the policy takes several months for first reading,
Right.
second. My recommendation would be to take that part that says board committees out of this policy and add it as a regulation. So from all of board committees down and just prior to consultants, you could add it as a regulation, and then the superintendent and the school board could look to see what exact committees you would like to have and make those changes immediately, and add and take away those that you need to. So for example, if there was next month you're thinking of adding a diversity and inclusion committee, or, with your list. Or you could just make the policy changes based on what you would like to suggest tonight, one or the other.
But I
Sorry,
think
who-
your point of making a regulation would, yes, move things faster, and that way, in the future, if boards want like 10 committees, 11 committees, they just got to change the regulation and not go through all this policy stuff.
Sorry, can you just clarify for me, who changes, when you make a regulation, who is allowed to change the regulation? Administrators or that?
Administrators, but we ask for the board to review.
Okay, so like, you couldn't just decide, oh, I want the committees to be this way one week and you just change them, and we would have to approve of it, of any change to a regulation.
You don't approve it, you would review the changes.
Okay, so are you hearing that, guys? So they could, do we want that? Do we want them to be able to assign or change committees?
Well-
And then we just review it?
I just have a quick question. I know I'm not on the committee, but do we even need that step? I thought when we discussed it at the full board, we were talking about making it as flexible as possible for the board could essentially just at the reorg decide what committees it wants and be just done with it that way.
Right.
Instead of adding that extra layer of a regulation.
Yeah, but I
maybe
think
just
Yeah.
have the policy be that the board can make up whatever committees it deems necessary when it does its organization. Just-
Yeah, I agree with the flexibility, absolutely.
right, so the policy has to change regardless, right?
Right.
Yeah.
But we could simply remove the list of committees from
Mhm.
any regulation or policy, not keep a standing list of committees, and simply change the wording here to say how many committees there must be at minimum. So for instance, we could say the president may appoint as soon after the organization meeting as practicable, members of the board to at least put in a number, standing committees. So we could say like at least 3 standing committees where they shall serve a term of 1 year. And then if we don't define the committees there, then it's just defined as part of that reorganization and appointment to committees.
Right, so are there some committees you're saying that should be standard, like buildings and grounds, finance, legislative, and curriculum?
I'm saying we wouldn't name what the committees
They
are.
are.
We would just say that we need a minimum of some number.
Of whatever 4 committees you want to create, right?
Right, yeah.
Yeah, basically, is what you're saying. Okay.
And then we would just keep the verbiage of the president appointing at the organizational meeting, the committees.
Right,
Or
so that
whatever.
will require us to agree and name what those 4 committees are.
Is there a reason you guys want a minimum number of committees and not just have the flexibility to appoint as needed?
I didn't think so. I'm
I think just,
not
you know,
having a
just-
number.
I'd keep it as open as possible.
Okay, so not even define that we need
Number of
any
minutes.
committees.
And then what about that verb or that wording at the bottom, ad hoc committees may be created, changed, and that would also add additional flexibility. So you can change them anytime, not necessarily just at the organization meeting.
Yes,
You keep that.
you could add those committees when needed, such as a feasibility study, an ad hoc committee, an investigative committee. They can be added at any time of the year when needed.
Do we have to agree on those committees, or are they appointed by the president?
They're usually appointed by the president with consultation. And one of the main stays is that there cannot be more than a quorum of board members on any specific, if you want to call it ad hoc or study committee. You can't have more than 4 members on any of those committees or studies. I'm not sure that clarified, but we do have to keep it under a quorum.
Under 4 board members, not the form of a quorum, you could have other folks on a committee.
Oh,
that are
absolutely.
not
Just,
that
right,
board members,
just,
just for clarification.
right, yes, like the feasibility study had many community members, but
Right.
a maximum of 4 board members.
There are actually 2 sentences that address that. The first sentence is committees shall consist of no more than 4 members.
Okay,
And the
perfect.
other
Yeah.
sentence is standing committees shall not include a majority of the membership of the board. And I think we should pick one of those. I don't think we need the duplication. And I think saying
Oh, yeah, right.
committees shall not
Yeah.
include a majority of the membership of the board is the better wording, in my opinion.
Yeah.
Can I ask a question? Dr. Marchini, what does PSBA say about committees? Do they give any insight?
You have to have set committees approved by the board so as to have, chairs, agendas, motions to move things forward, et cetera.
It doesn't specify like what kind of committees you need or how many or anything like that, right?
Not that I'm aware of.
Okay.
The only thing I like the flexibility, but there has to be a procedure to create and approve a committee. So as to have it organized in a way where you'd have public meetings.
Well, I like, to be honest, I like the past procedures of doing it after the reorganization in December, because you're going to have new board members coming on. I think the ad hoc committee allows flexibility for when you need to add a committee to the board. So I don't know that I would necessarily change that, but if PSBA doesn't give a ton of direction on what you need, I think keeping it pretty minimum in language, Jennifer, is probably fine.
Would you like me to come up with a draft, and at the next meeting, we can review that draft?
Yeah, so I think we're striking committees shall consist of no more than 4 members because it's a duplicate. Although if we want to take out the word standing in the other one and just say committees shall not include a majority of the membership of the board, then that would cover standing and ad hoc committees both.
Yes, it would.
Yep.
It would remove the redundancy.
Right, and we take out the entire list of 7 committees and change it to the president may appoint as soon after the organization meeting is practicable members of the board to standing committees. So we just take out the following.
Do we want to keep where they serve a term of 1 year? So
Yeah,
that we know that that's a yearly thing.
where
Yep.
they shall serve a term of 1 year. Mhm.
Yeah.
Yeah,
Yeah.
that is all by PSBA law. You have, or state law. Every year you have to reorganize. Reorganize.
So really, what we're really doing is taking out the names of the committees mostly, and then just streamlining the language, which I think is fine.
So if I'm taking out the list of committees, making those other minor changes, do you want to move that forward to approve? Or would you like me to come back with a draft to another LNP meeting for review?
Ellen P., do you have a strong opinion?
I say draft.
If you do draft, then you're going to delay
It's going to delay it, but
Yeah.
the time to actually create the committee.
understood. But if he creates something that we don't all agree on, that would delay it as well.
Mhm.
You just want to roll the dice and hope it's good, or do you want to like a preview? Can we just preview it? And I mean, you're right, Kathy. It would delay it. So can we just preview it and then say when it's time to move forward, we just move it forward? I mean, do we have to wait for a committee meeting to see it, right? To at least view it.
So
Well,
if
you
we
would-
make a motion to move it according to what I just verbally described to the full board, and then Dr. Marchini, you can get that out to the committee and we can say whether it met what we thought we were agreeing to. Does that work?
You wouldn't be able to deliberate without a public meeting. However, what you said, I would then have in board information for the next board meeting, and you could review it at that time. The whole board would have to review it prior to approving it.
Yeah, that's the fastest path.
That's-
to
Well, it's
read.
also the first reading, so that's why there's multiple readings. You would review it, and there's a first reading at the board meeting.
That's
Just
true.
point
So-
out, if you move
yeah.
it forward here, Jennifer, and it goes to the board and you don't like it, it's fine. You didn't lose any time. You still then can go to second reading. But if you do like it and do approve it, then you've saved time. So I think there's
Yep.
no disadvantage to moving it forward.
All
Right.
right, so let's get a motion to move forward with the changes.
So moved.
And second,
Second.
Second.
all right, thank you. Good discussion, everybody. Next is.
Sorry,
item
Jennifer, I don't mean to
Yeah,
interrupt.
Go ahead.
I just want to be cognizant of time because we were
Mhm.
supposed to start the curriculum meeting. So I know that there's some other discussion points on here. So I don't know if you want to hold on any of them or see if you can have a quick discussion. I just want to make sure that we try to stay on time here.
Yeah, so we'll try to do quick, thank you for the time check. The next one is on meetings code 006. And I think we had wanted to possibly make some changes regarding appearing virtually at meetings.
Yeah, 006 just is on there as reference to 006.1, attendance at board meetings via electronic communications.
Mm-hmm.
I don't know if there's any, unless I'm wrong, I don't know if there's any major changes to 006, but the attendance at board meetings via electronic communications, the board or the committee gave me a list of changes to make for 006.1. We put together a draft, asked our district solicitor to review.
And
Good.
this one I had asked you to put on here because of the reference to committee of the whole. We need to change that wording over to working sessions.
Okay, we
So
can
the
do that.
section is already called work sessions, just change the wording there. And then we'll review that one again.
Okay.
All right, anything else from the rest of the committee? So we'll review that one again and 006.1. Have a really quick discussion around what we were changing here.
So just quickly, this is, it considers emergency situations, and it also considers what the school board directors were talking about, where electronic communication, folks can participate by electronic communication.
So we are still covered by electronic communications right now, right? Or the special emergency condition.
Yes, that's at the very end of this policy, the emergency conditions. However, there was a question about when it's non-emergency.
Right, in order to move things along, I think we'll take a look at this. The one thing that I see that we do need to address, back to you, Dr. Marchini, is need to choose the number of members. 5 or 6 school directors shall be physically present at a board meeting.
Mhm.
Does the committee want to choose one of those so that he can make that change for our next review?
Gosh,
5 would make it a majority.
There are some votes, though, that are not a simple majority.
Good point.
Yes, I think it should probably remain 6. I think there are some votes that need to be a 6 vote for passage.
okay, then why don't we go with 6?
Sounds good.
Okay,
So we have to rework it.
Okay,
we can make that change.
then we'll come back to that one once you've made that change and discuss it with meetings. Naming of school facilities.
I'm
Did we
sorry, are we bringing this back to L&P for the next meeting, or are you moving us forward as is?
no, we'll bring it back to LNP so we can have the discussion.
Okay,
I think unless you guys think that we're covered.
No, let's bring it back.
Bring it back.
Okay. Naming of school facilities, we might be able to pass that one along if the changes were made. Yeah. Presented publicly to the board. The board will inform the superintendent. That's a word change on page 1 of the naming. And oh, the other thing that we do need to change on this one was Buildings and Ground Committee is currently referenced in here.
Mhm.
So we want to take that specific committee name back out. of the draft?
Um, I haven't read the draft, but I think we have failed to designate a time frame. Am I correct?
Yeah, we were talking about that before.
Right, we need to designate a time frame that some of these namings, and maybe it just might be something as simple as like either 5 or 10 years and then to be reviewed. But that is an omission. We have not done that yet, and that needs to be done.
Right, so Melissa, are you saying that, so there's two parts to that. There's a minimum amount of time. So if, let's say we wanted to rename something, but the current name has only been there for 5 years,
Mhm.
right? So are we saying that it has to be there for at least, I'm just going to throw out a number, 10 years before it can be renamed, right?
This policy does say the board shall approve the length of the term of the naming.
Right, exactly, exactly.
We did
Can't we
add
just
that.
go with that, like in each individual situation?
Mhm. But we haven't done that. I mean, when we did approve naming of the field, I don't think there's any time designation. And the same thing with the approval of the Dave Michaels entrance to the track. There is no time designation, and also the latest one with the Ron Pearson training room naming, there's no time frame designation. So we should probably, I mean, that's up to the committee, but there should be some designation, I think, because it is in there in the verbiage that it should be there.
You would have to, at the time that you do the naming, you'd have to determine the length as per this policy, but it also has by 5 votes, you can revoke the name as well.
Correct.
That's farther down.
Oh,
So-
it is further down. I was gonna ask that exact question. I
Yeah.
didn't see it.
So rather than saying, for 10 years, I think it would be dependent on the board's decision on that. And then they could also revoke.
Right. Maybe it's just something as simple as it should be reviewed every 5 or 10 years or something like that. Again, to keep some kind of flexibility. But there should be some opportunity for review, whether it's to renege on that or to take it away because of something that occurs, or to allow it to keep going. If nobody else wants to do something, I think it should be clarified to some extent. A review might be a very good way to do it. But that's up to the committee. I'm just raising the issue.
I mean, there's a few options here.
There are.
Yeah, I'm seeing the maximum term is will not exceed the expected life or the time when the district owns the facility. So that seems to have kicked in for anywhere we didn't approve a specific length of term, if I'm reading this correctly. And then it says once the facility has been named, it shall not be renamed prior to the expiration of the term, except for a compelling reason. So that seems to say we should not be reviewing it. So I would say that it has been a failing in our naming process if we have not approved a length of term shorter than the expected life or time when the district owns the facility.
So does the committee want some specific change or to move it as is?
Trying to understand that myself.
Yeah, so
I
Yeah,
think the bases are covered. If the board has to approve the length of naming and can revoke the name and can't, I don't know, I think it says everything it needs to say.
So essentially, we're leaving things, if they've been voted on in the past and the term was not set, they will keep those names forever unless there's a compelling reason.
right, unless there's a compelling. I'm fine with that. I don't think we need to review it. It's just that 20 years from now, if someone wants to rename the track to something else, then we would review it, but also have a right to change it if we voted yet.
I lost a little bit of that, but I think I agreed. All right, so are we
That's fine.
okay with passing this along to the full board for the purpose of getting that change in the first paragraph that we cared about? Well, the first one under authority procedure. A motion to pass this along, except without the Buildings and Ground Committee name in there.
So moved.
And a second,
I think I'll second that.
All right,
And that's for first reading, right?
for first reading, yes.
Second.
Mrs. Munson, in the interest of time, the educational equity one there is just a standing agenda item. The district is still working on the educational equity policy. So I just keep adding it on there. And then the procurement 626C basically is the just change from the federal programs for 2021.
Right, it's the quote and bid thresholds, they change annually.
Right.
Right, so I'm okay with just moving straight to 501 and asking for a motion to approve regulation 626C. Wait, do we approve it to go to the full board or we just approve receipt of it?
Regulation is just
Regulation.
that you've reviewed it. You don't have to make a motion, just that
No
you've
motion.
reviewed it.
Even easier, okay.
Okay.
Committee, are you okay with adjourning at this point? Any,
Oh, hold on.
Yeah,
Well,
yeah.
I
okay,
just want to touch on the equity policy real quick, just because we've
Sure.
talked about how we're going to be working on this equity policy. So it is a work in progress. So we've got a baseline. The board is still working on defining what equity is. So just so we don't brush through it, it is still a work in progress, a major focus.
Yes.
As John had mentioned, Dr. John had mentioned at the last meeting, was it last week? When was that?
That's
He
Monday.
had asked about an equity committee. So it is still a major focus. I know we had continued to direct people that we were to talk about it here. This is just the draft. Before you convene, I just want to let everyone know if they are interested in attending the curriculum meeting, they need to click on the link for that, which is on the homepage, because it is a separate link for that meeting.
right, and my apologies, I took the time crunch as meaning that we should not get into a really meaty discussion like equity, and I believe it will be a very meaty and good discussion when we get to it. So my apologies for anybody who did tune in specifically for that.
Can I just say two things? A, let us at least start thinking about what we want to do with a equity advisory committee. Think of what we've done in the past as far as inviting parents, teachers, admin, board members, so that we can have, that not be stalled too much longer. And secondly, in our next LMP, why don't we start with equity so that it doesn't get bumped again?
Yes, I would like to do it the other way around next time. I agree. So Dr. Marchini, can you rearrange it so that we don't have another running out of time
Absolutely.
situation?
And for the
Thank
record, you did a great job, Mrs. Munson. Very nicely done.
All right, so I know we're late on time, but for the extended board, do we have any comments?
No.
Okay, and any urgent public comments that people needed to get in before we go? Let's see, am I able to check the raise hand? All right, I am not seeing anyone in the community with their hand raised. 3, 2, 1, may I have a motion to adjourn?
Motion.
Second.
All right, thanks, everybody. Talk to you at the next meeting.
See you soon.
Okay.
Thanks.